Welcome to Faith and Politics, a show dedicated to discussing issues surrounding the intersection of church, state, and politics, and the examination of whether you are allowing your faith to shape your politics or are your politics starting to shape your faith. In other words, what do you do when God and government come face to face? Let me introduce you to our panelists that we have for today. First, we have Mr. Todd McFarland, Deputy General Counsel for the General Conference of the Seventh-day Adventist Church. Next, we have Mr. Lawrence Brown, who's the Associate Public Affairs and Religious Liberty Director for the Northeastern Conference of the Seventh-day Adventist Church. Next, we have Andre Wang, who's the General Counsel and Director of Public Affairs and Religious Liberty for the North Pacific Union Conference. And we have Ms. Melissa Reed, who is the Washington Liaison for the North American Division of the SDA Church. Great to have you guys with us and looking forward to our conversation today. There's a significant piece of legislation that took place in 2022, and this legislation was called the Respect for Marriage Act. It's an act that was put in place that really in large part ends up dealing with the concept of the Defense of Marriage Act, which many people call DOMA. The Supreme Court effectively rendered DOMA inert when its landmark decision with the United States versus Windsor, and it also had dealt with it to some degree in Obergefell. But the bill actually is coming in that will cause some new activity to take place as it relates to same-sex marriage, as it relates to protections that would be needed, and making sure that religious liberty qualifications have been put in place so that hopefully it doesn't end up infringing upon certain religious organizations. Melissa, you spent a lot of time down in Washington working on this act and really understanding some of the nuances that many people didn't quite see was happening. Can you tell us a little bit of what the process was like and actually how we ended up getting to hopefully a great resolution?
Sure, happy to do that. So, as you mentioned, Orlin, this is a really narrow, targeted piece of legislation that essentially is congressional affirmation or codification of same-sex marriage. At the same time, it also is that interjurisdictional recognition of same-sex marriage, that requirement, and overturning DOMA. But I think that the final piece of legislation that we've seen based on the amendment that was included in the Senate version of the legislation is something that we as religious freedom advocates, or those that are paying attention to religious freedom issues, can feel a lot more comfortable with than what we saw, what was first passed or introduced and passed in the House earlier this year. Again, this is a very narrow piece of legislation, but after conversations with the organization that I represent, the Seventh-day Adventist Church, as well as many other faith partners and religious freedom advocates, Congress really responded and said, yeah, if we're going to address LGBTQ and same-sex marriage, then there needs to be an acknowledgement that good people with, good beliefs can differ on the legitimacy of same-sex marriage.
So Todd, it looks like we got some amendments that were put in at the Senate level that may not have been perfect, but looked like it came in and at least gave us a little bit of more comfort for more religious organizations. What are some of the things they ended up adding in there?
So this bill has a number of protections in for religious liberty. They are primarily designed to address any potential problems that the bill could cause. So, for instance, one of the concerns is after Obergefell and after the then Solicitor General's comment, people were concerned that it could address the tax-exempt status. And so there's a specific provision in it that says that this bill cannot be used to deny people other benefits such as tax-exempt status. Now, one thing I want to be very clear on, this bill does not provide complete protection for tax-exempt status for organizations that uphold traditional marriage between one man and one woman. But it does address the issues that I think that the bill could potentially raise. It also talks about marriage ceremonies and churches making space available, and also reflects the language that Melissa referenced from Obergefell, which of course was the case that made same-sex marriage the law of the nation, about decent and honorable people. So the bill really itself is not going to do much, if anything. It only would really come into effect if the Supreme Court were to overturn Obergefell, for which there seems to be precisely only one justice that even has an interest in that. The other 8 have very, very little interest in that issue. So again, this is a very narrow bill that addresses an issue that is, quite frankly, very unlikely to ever come up. I should also mention it isn't just same-sex marriage; it requires interjurisdictional recognition of, but also interracial marriages.
You know, Andre, it looks like this is one of those pieces of legislation where somebody was looking to step in and to take care of a quote unquote problem, but maybe being more political than it was necessary. When you take a look at it, what do you think we were trying to do from a political standpoint here that they wanted to really cover? Was this possibly saying, well, we always thought the Equality Act was going to move forward and handle certain things, and this becomes kind of like the Equality Act light? Is that what we possibly are seeing here?
Yeah, you know, we all know that that this legislation is really kind of a reaction to, as Todd mentioned, to Justice Thomas's concurring opinion in Dobbs. You know, for fear that the Supremes may overturn cases like Loving v. Virginia and Obergefell, and call into question really the legitimacy of tens of thousands of marriages. But you know, I wanted to also add something that Todd mentioned, that specific in this legislation, that it is not just that the provision says that it will not alter any status, benefits, rights that someone enjoys, which includes tax-exempt status, but also applies to things like grants, contracts, education funding, scholarships, certification, anything. Really, so it's important really to understand that the law really doesn't have anything to do with churches in the first place. But what it does do is tell the federal government, which of course is not a church, that it must recognize interracial and same-sex marriage as it does with any other marriage. And it tells the states that if someone has a valid marriage in one state, that other states have to recognize that per the full faith and credit clause.
You know, Lawrence, when you take a look at a piece of legislation that's so narrow, but obviously deals with an impact that could just be touching tens of thousands, when you see in particular in a jurisdiction like in New York, where you have so many different walks of life going on, what does a piece of legislation like this normally say from a small picture and a big picture standpoint?
Well, you know, it's interesting because as I shared with some people before, I was in law school when New York voted to allow same-sex marriage. And we were having, and interestingly enough, I was actually doing family law at the time. So it made for some very interesting discussions in class. And one aspect of what happened here in New York, I don't think this is well known, but the law made provision for the fact that religious liberty would be protected in the sense that someone, whether it be a pastor or whatever the case may be, refusing to conduct a same-sex wedding, if he or she were successfully sued as a result of that decision, that successful lawsuit would trigger a provision in the law that would actually terminate the law here in New York. I think when you narrowly tailor, you're endeavoring to at least avoid what I like to call a parade of horribles, but sometimes your best attempts to amicably divide the baby doesn't always work out. But here, I think when the topic comes up, a lot of people conventionally their nightmare is that somebody will put a gun to their head and say, you have to marry this person. And obviously that's not how the law works. So.
You know, Melissa, I got to ask you this, though. There are a lot of religious organizations in particular that have very strong views on marriage, and sometimes they're uncomfortable with even hearing about religious leadership even engaging in these type of conversations. I mean, what would you say to those individuals, you know, as to why do we even get involved? Why engage? Why not just let the system do what it does, and we in turn will be protected, you know, hopefully by our own God?
Sure. I mean, and that's a legitimate question. I would love to be able to advocate for a standalone religious freedom piece of legislation, but unfortunately, there's not an appetite in Congress for such a piece of legislation. If we look around, you know, we see over 70% approval rating in the United States for same-sex marriage. This is the reality that we live in. This is the space where, you know, we need to have these conversations. I think, fortunately, for those, you know, Christians who have a, an understanding of traditional marriage, as created in Eden and ordained by God, that we recognize we've been in this kind of space before as far as having tensions between other social issues, and yet God has always made a way. And so I think that that's something, of course, we'd like to see, more people maintain our understanding of marriage. But that doesn't, certainly doesn't need to give us a defeatist sort of attitude.
Well, Todd, it sounds like we didn't get everything that maybe religious organizations would like. What are some of the pieces that maybe would have been a little bit more helpful to certain religious organizations to see take place here?
So I think a lot of those could be found in the bill that the Adventist Church has also worked to pass called Fairness for All. So it would have been nice to have had, in fact, Senator Lee made an amendment to this effect, but it didn't pass, a explicit protection for tax-exempt status, not just limited to this bill, but overall, right? Explicit grant protection, more explicit protection in employment. A lot of extra protections that aren't limited to this bill would have been great to have seen. But, as Melissa said, there hasn't been as appetite for a standalone bill on that. And the amendment that Senator Lee proposed did not get, it needed 60 votes and it didn't even get 50. And so those are protections that we intend to work on and we want to see passed. And members of Congress and the Senate and others in the public sphere that said that the religious liberty protections in this bill weren't sufficient are not wrong. They're not sufficient in the general scope, but what we did feel like they were sufficient and addressed was the additional potential issues created by this bill. Remember, people who think that tax-exempt status is at stake because the government recognizes same-sex marriage, all of those concerns existed well before this. This was simply a reaction to a line in a concurring decision that got no other votes in the Supreme Court about re-examining Obergefell. And so understanding the limited protections is necessary to understand the limited scope of the bill.
So, Andre, when you start to see people juxtaposing the conversation with the Respective Marriage Act and they start talking about the Equality Act and Fairness for All, is it fair to say that you don't have to actually think about all three of these pieces of legislation together, that this one here is pretty much a narrow scope, and to some degree, whatever your concerns may be with the Equality Act and Fairness for All, that maybe is just simply a fight for another time?
Right. Yeah, and legislation really has its own scope, but then also in the context of public opinion, it's broad, right? We all lump it into one bucket, and so what we do in the halls of the Capitol, not only in Washington D.C. but in our state capitals, in addressing basically religious liberty on a bill by bill basis. That there's no impact on religious liberty and conscience. That as this bill also, or this law now says, there's nothing that shall be construed to diminish religious liberty, and that specifically nonprofit religious entities, churches, mosques, synagogues, temples, shall not be required to provide any services or goods for any marriage. So really, there's nothing in this law that shall be construed to deny or alter any status is probably something that we just need to be vigilant on as we looked at legislation both in the federal and state levels.
And I think you really hit it on the nose, and Melissa as well. The idea that there are pieces of legislation that are out there that if you don't engage, what will end up happening is you'll see things get created right around you. One of my favorite sayings is either you're sitting at the table, or you're going to find yourself on the menu. And if you don't put yourself in the right scope, what we're trying to do, hopefully in large part, is to protect our religious organizations wherever we can. There's another case I think that we had already mentioned, and it was talking about the seminal case that really kind of created the whole concept of same-sex marriage. We have a lot of our viewers that hear these conversations, see about these pieces of legislation, and have to ask themselves, well, where did this all really get started? Well, we have the case that was called Obergefell versus Hodges. And in that particular case, it really laid out a very close Supreme Court decision where it came out, I believe it was 5-4, in which it was ruled that you could have, quote unquote, same-sex marriage became the law of the land. This particular constitutional question was one that really started asking whether or not that this was something that legally could be required. you had two questions that were really kind of focused on, one that was talking about, bans on same-sex marriage, recognizing same-sex marriage, exactly what that recognition question should look like. But Obergefell really came in, kind of set the tone, and everything that we hear now is really either talking about taking away from that particular case or adding to that particular case. Todd, can you tell us a little bit about that seminal case? It seems to be this is what was the law of the land. It kind of set us in this direction, but I think it helps everyone to have a better idea of where we started, to have a better idea of how we ended up where we are today.
Sure. So Obergefell was a 2015 decision, 5-4, Justice Kennedy writing for the court, that required states to recognize same-sex marriages and perform them on a U.S. constitutional basis. So we had same-sex marriage before then in a number of states, and same-sex marriage had been recognized there, but states outside of those were not required to recognize same-sex marriages. And Obergefell said in that opinion that prohibiting same-sex marriage was unconstitutional as a matter of the U.S. Constitution. Prior states, I believe Massachusetts was the first one that had ruled for same-sex marriage, and it kind of stuck. Hawaii had done it back in the 90s, but then that got overturned by the legislature. But Massachusetts was the first one, if I remember correctly. And then what that happened then in 2015 was it was the law of the land nationally.
Well, Andre, one of the things that we've been seeing, and some would say that we're looking at a Supreme Court that's starting to be more of an activist court, and many will say it's because of the ineffectiveness of the legislative bodies, and therefore there's been some talk that there's some justices that said, we'd like to re-examine that again. Maybe we need to be looking for a similar case. Do we see the possibility that this may be something that may be coming down the pike again at the Supreme Court, or as we've kind of alluded to here, that maybe this is really one of those hot potatoes that the court really doesn't want to get involved in again?
Well, here we are talking about it. Justice Thomas, with his one line in his concurring opinion in Dobbs, sparked this whole discussion. If you look at the majority opinion of Obergefell, you have Kennedy with the opinion, Ginsburg, Breyer, Sotomayor, and Kagan. Within the minority, Robert, Scalia, Thomas, and Alito. Would Obergefell have a different outcome with this court? Absolutely. And so, with the current court composition, I submit that we will see more rulings analyzed and decided through the lens of religious liberty protections and freedom of conscience. I think that what Justice Thomas has sparked, we will see probably more, like I said, more decisions coming through with that analysis from the Supremes.
Well, what's interesting, though, but it looks like the Roberts Court, if anything else, looks like it's trying to be a disciplined operation that isn't necessarily taking on cases or trying to engage in activities just based on, the conversations you hear in the public. Melissa, it sounds to me that, really to open up this box could potentially put Congress in a tough position, put the Supremes back in a tough position again, that maybe right now this is the hot potato that nobody really wants to touch directly, and you might want to just stay away from it. I mean, what are you hearing down on Capitol Hill?
Yeah, well, as you know, Todd mentioned earlier the Fairness for All Act in our previous segment. And, again, that's working around the space in a legislative area. And we certainly have wished that there had been more engagement, right, or desire for engagement by our members of Congress there. It's interesting. I was looking back at commentary back from 2015 from, faith partners about what potentially this ruling could mean. And, I was actually looking at an article from our colleague, one of our panelists today, Todd McFarland, and he was talking about how it's not going to be the challenges that we're going to see there, or the religious bodies we're going to see, is not about pastors having to perform same-sex marriages, but actually it'll be the related ministry areas, whether it's the educational institutions, the social service, religious affiliated social services organization. That's what we've seen come to fruition, right? And that's why we work in this space of fairness for all, is because we have seen challenges in those areas as far as employment and public accommodation and even housing. So just, Todd McFarlane, I will now, he's a prophet as far as.
Well, I've heard Todd call a lot of things, but profit wasn't at the top of the list. But, but in response to that, Lawrence, I got to ask you this, have we gotten to a point now where sometimes you have to look at certain pieces of legislation and you just have to say, listen, the cow has left the barn? As it relates to same-sex marriage, it's the law of the land right now. To come back and tinker with it could create a powder keg that maybe we're not ready for in this country. And, are we getting to a point where sometimes you just have to let well enough be well enough if you've got the protections in place that protects, other groups?
Well, conventional wisdom would say that, but there's another issue that factors in here as well, and that is the Supreme Court has an optics problem. It is seen by many people as being an institution that has strayed away from the norms that governed it in the past and has turned into some type of political entity that has abandoned process. In fact, I need to make a T-shirt that says "Process Matters," that has abandoned process and now just relies on the fact, well, there's more of us than of you, and we're going to do what we want to do, regardless of what the legal underpinning is or anything like that. You don't want to be a court that is largely viewed as one that can't be trusted because your ideology overwhelms your jurisprudence. And to the extent that they're sensitive to this optics problem, it will be interesting to see how they manage going forward. I have said before, and I say again, the only way they manage this optics problem is to be seen as being a court willing to make decisions with good legal underpinning, even when they fly in the face of what the people who put them in power were hoping would happen when they put them in power. And if they fail to show that balanced approach, then they will continue to carry the moniker, this is a court not governed by the rule of law, but governed by political expediency. And I'm certain that is not where they want to be.
Well, Todd, I would say that I think the Roberts Court, in particular with Chief Justice Roberts, is trying to be a disciplined court, is trying to hopefully operate in a way where, I think many of the comments you would see from him wants to make sure he's not viewed as being somebody who's engaged in political expediency in any way. What are your thoughts as it relates to, where the court leadership has been really trying to take this messaging?
Well, I think it depends on who you're talking about, right? So Roberts, when he was more fully in control of the court, when it was a more 5-4, listen, he famously switched his vote at the last minute to save the Affordable Care Act, and say that it was a legitimate tax bill. And other changes. Dobbs, the abortion case, he said, well, we could strike down this bill, but in a narrow way and not overturn Roe versus Wade. So, yeah, Roberts has been very incrementalist, maybe to a fault. I simply think some of the other justices on the court just are not willing to sort of be that patient and be that incrementalist, and they want to see sort of more sweeping decisions. And quite frankly, when it came to Dobbs, he just got outvoted. And, I think, there is something to be said for process. But at the end of the day, the justices that are on the court, they're not politicians in the traditional sense, but they do have a certain worldview, right? And that worldview is reflected in their jurisprudence. And when you have the court making the important decisions it does and being thrust into these arenas, then you're going to have decisions that reflect their worldview. And that has happened both on the left and the right. I think we talked about this in a different panel. I think the people that are calling the court, illegitimate or its legitimacy being questioned mainly just don't like the outcomes, right? I mean, Obergefell was not the model of constitutional reasoning. It was, in fact, pretty bad on that level. Now, the people who like the outcome, and that's why I think some of the liberals voted for it and didn't have any concurrences. But its constitutional analysis was not anything to write home about, and I've not really seen too many even progressive or liberal constitutional professors who support the outcome really defend how Kennedy got there. But because it was an outcome that people liked, all of a sudden, well, that doesn't call into question the court's legitimacy. So, court moving forward, I think is careful about the steps it takes. But, elections matter, nominations matter. And to some extent, the court, does need to reflect where the country's at. And I think that's kind of what we're seeing right now, a very split country.
I mean, Andre, are we being naive in trying to act as though we believe at some point the Supreme Court is not going to be impacted by politics? You get put in for a lifetime appointment. You get appointed by somebody from a specific party. We've seen sometimes that parties have even delayed putting Supreme Court justices on. Are we being naive in not believing that that's really as much a part of the process as anything?
Well, it is. I mean, the president's a politically elected leader, and so his appointments are made through that prism. But you look at Justice Thomas. Justice Thomas, who was appointed to the court in '91. There's been no secret as to his jurisprudence and statutory interpretation. That there is no right to privacy in the Constitution. That any right that is not expressly enumerated in the Constitution, Thomas is very dubious that the Constitution protects it. The Constitution does not have the word abortion or the word marriage in it. And so, most justices for decades have felt that, that there are some rights that are just so fundamental to our way of life that they have inherent constitutional protection. So I think that the whole notion of being a disciplined court also goes to the jurisprudence of not only the individual justices, but all the justices holistically.
Now, I have to let that be the last word, Andre, but I think we're right on point in deciding that, this is a nuanced situation here. Trying to figure out how you balance politics and the law, but then also trying to figure out how you have to step in and maybe sometimes correct or at least augment, a legislature that's not being effective in any way. And I think this is going to be a battle we're going to see for a long time. Andre, tell me something I don't know.
I'm going with a jurisprudence prediction this time. The Respect for Marriage Act will make its way to the Supremes as soon as possibly next term, and it will be upheld with Roberts and Kavanaugh joining Kagan, Sotomayor, and Jackson.
Wow, that's a big one. Lawrence, tell me something I don't know.
Well, do with this fact what you will. But in 2008, this country had just over 500,000 same-sex households. This year, for the first time, it crossed over the million household mark. In fact, 1.2 million households now are same-sex households. That's a 120% increase since 2008.
Wow, Todd, tell me something I don't know.
Back in 2013, Nate Silver of the 538 blog had predicted that by 2020, same-sex marriage would have a 60+% support in the United States. Now in 2022, we're at a little over 70%. So we are ahead of where the predictions were as far as nationwide support for same-sex marriage.
Wow, Melissa, tell me something I don't know.
All right, Orlin, I think my facts is going to be the most important of the ones mentioned on today's show. So, we were talking about the Respect for Marriage Act earlier in the conversation. One of the key sponsors for making sure that that Religious Freedom Amendment was included was Susan Collins, who represents the state of Maine. Orlin, did you know that the state of Maine has 65 lighthouses?
No, I did not know that. Well, listen, thanks a lot for being with us today. Great conversation and looking forward to doing this again soon. Thanks again for being here with us today. Hope you enjoyed our conversation. Just remember, if it's about God and government, it's faith in politics. See you next time.